Domestic violence. Domestic violence is a behavior as opposed to a belief, but in the Sharia system, it seems to be a belief.
Yeah, it's certainly a belief. You can't have something in the Quran and have Muslims say that they're against it if they are going to be believing, observant Muslims.
Has it grown in Texas?
Texas is under assault from Islamic groups and foreign powers. Qatar, Turkey, Pakistan, Saudi Arabia, waging a stealth war on our soil, planting flags via mosques, schools, and enclaves. They follow the Muslim Brotherhood's, quote, civilization jihad plan from the 1991 explanatory memorandum. Destroy America from within by imposing Sharia and achieving global dominance, and is now deeply entrenched. Reversal requires urgent action.
Mr. Onder for 5 minutes.
Thank you, Mr. Chairman. I yield my time to Representative Biggs.
Thank the gentleman. Mr. Biggs.
Thank you, Mr. Chairman. Thank you, Mr. Onder, for yielding time. So I'm curious, Professor, you're familiar with a case called Reynolds versus United States, 1879 case?
I am, yes.
I think you must be, because part of your rationale on page 6 of your statement seems to go right along with the rationale of the original Reynolds case, which was that belief versus practice. Belief okay, practice not necessarily okay, right? You would agree with that, right? I'm looking at page 6, your line that says, many aspects of Sharia law govern such issues as prayer, fasting, and dietary restrictions that apply to religious behaviors. You would say that stuff's okay, protected, even under Reynolds, right?
Certainly free exercise of religion includes...
So you would agree that praying, fasting, dietary restrictions, that's A-okay under Reynolds, right?
So I do not think Reynolds gives a government a general power to ban prayer, fasting, and so on. No,
that's right, and I agree with that, right? But in that particular case, the court said polygamy is dame. It is bad. You cannot practice polygamy anymore. You remember that?
I do.
Yeah. And so now I want to go to you, Mr. Gillay. Let's just talk about some of the practices that seem to be broad in this idea of Sharia, because Sharia is an expansive term here. So I'm looking, and it says here that where Sharia is, and this is on page 1 of your statement, the enforcement of foreign child custody judgments. That's coming into America, and we're relying on Sharia interpretations from other places. Is that accurate?
Yes, there's been numerous cases in which child custody judgments from either Islamic countries or even non-Islamic countries that have Sharia courts.
How does that square with Reynolds, for that, where you have a distinction between religious practices and behavior? And here we have Sharia determining actual child custody issues, totally irrespective of religious practices. How is that square with Reynolds?
Well, clearly, Reynolds would allow the government to regulate child custody, whether or not the child custody rules were favored or disfavored by a religion. However, there is a lack in our law of addressing comity of foreign judgments and the constitutionality of the process by which those foreign courts reach their judgments. There's even a Ninth Circuit case, the Nauco case, where the Ninth Circuit explicitly said that you can't do a constitutional analysis on a foreign judgment. So under current law, it appears as though foreign courts can do things that our courts would never imagine doing, would clearly violate constitutional rights, and those judgments are being brought here, and those judgments are being, on many occasions, enforced.
Yeah, and they would be inconsistent with American jurisprudence, but somehow we're incorporating some foreign jurisprudence into ours. And so now I'll go to you, Mr. Spencer, for just a sec here. On page 2 of your statement, you point out that the Quran states a man should beat a woman from whom he fears disobedience. Domestic violence is a behavior as opposed to a belief, but in the Sharia system, it seems to be a belief.
Yeah, it's certainly a belief. You can't have something in the Quran and have Muslims say that they're against it if they are going to be believing, observant Muslims. And the problem becomes when they act upon it in a Sharia context, then you have the precedent of Britain that I was explaining, that instead of referring it to the criminal courts as they had agreed to do, they tried it under Sharia, and told the wife to go back and try to please her husband instead of prosecuting the man who was committing the domestic abuse.
And so Sharia actually became an institution or a third rail that replaced the British judicial system, at least in that particular case.
Exactly.
And Ms. Shields, ultimately this really is the nub of why we're here today. We see Sharia, we see its expansive nature. Some people want to frame it in a certain way as just, it's how we pray, it's how we call to prayer, it's those types of religious practices, but it actually has massive institutional ramifications. Has it grown in Texas? What did this start out with, and how has it been impacted in Texas? And I'm almost out of time, so Mr. Chairman, if you can answer that question.
Yes, Mr. Chairman, members of Congress, Texas is under assault from Islamic groups and foreign powers, Qatar, Turkey, Pakistan, Saudi Arabia, waging a stealth war on our soil, planting flags via mosques, schools, and enclaves. They follow the Muslim Brotherhood's, quote, civilization jihad plan from the 1991 explanatory memorandum, destroy America from within by imposing Sharia and achieving global dominance. This has been built for over 35 years and is now deeply entrenched. Reversal requires urgent action. Texas is ground zero. Sharia doctrine demands subjugation of non-Muslims.
Ms. Shields, you're going to wrap your answer because we're running over time, but go ahead and wrap.
Yes. So as Rare Foundation's USA Texas Director, I travel across the state constantly. What I'm hearing from people in their communities who message me all of the time of what's happening in their own backyard is that they are very afraid of the Islamic Sharia expansion they see happening in our state and what that means because they see it happening in other places in America.
Thank you, Ms. Shields. With that, I'll now recognize the ranking member, Mr. Raskin.
Mr. Roy, thank you very much. And I find something to agree with in what all of the witnesses said. Let me start with Ms. Skild and Mr. Spencer. You basically have said that there are fanatics within the Islamic faith who use the religion for their own purposes. And I have no quarrel with you there, except I would extend the point to say that's true of fanatics in every religious tradition, in every religious community. In fact, any particular crime or violent act that you would attribute to Sharia fanatics, you could also find taking place in other communities too. Now, Mr. Gillet, am I pronouncing your name right?
Yes, you are. Thank you.
And you make a very interesting point to me, but I want to try to break it down if we can. So let me start with this. If there is a couple that are faithful Muslims who say that they are governed by Islamic law, but they get a divorce and it's a custody arrangement, and they go to a regular family court in any state in the country, do you agree with me that the standard that must govern by a judge is what's in the best interest of the child? Even if, say, the husband is saying no under Sharia law, and I'm making this up because I don't know if it's true, but under Sharia law, if the husband wants custody, he gets custody. That would be not just wrong, but it would be outside of the law for a judge to say, I'm not going to use the law of the state of Colorado or Tennessee or Maryland. I'm just going to use Sharia law because both of you are Muslims.
Every state in the United States applies the best interest of the child standard to some extent. Every state in the United States applies the law of that state. However, under the laws of arbitration and the laws of comity of foreign judgments, they will sometimes apply.
Okay, so that's where I'm going now. But just to be clear, it would be a violation of the law and clearly reversible error if any district court in the land said, we're going to use Orthodox Jewish law or Islamic law or Seventh-day Adventist law in order to decide a custody dispute or a marriage dispute. We can only use the secular law, and it is reversible error if it doesn't. Now, you raise a really interesting point, though, which is what happens if there is a society which actually has a theocracy, like Saudi Arabia, for example, which I believe uses Islamic law and Sharia law. Okay, so let's say there the husband, again, hypothetically, because I don't know the theological particulars, but let's say the husband gets custody because he wants custody. Then they come over to America and the wife argues, I should have custody under the best interest of the child standard. Are you saying that under the comity of laws or respect for foreign judgments, that an American court is bound to accept the judgment that took place in another society?
I'm not saying that. The Maryland courts have said that in the
Yeah.
case of Hussein versus Malik, and it's happened in other instances.
Yeah.
The problem, Congressman, is that although the law of the states is clear, the Uniform Child Custody Jurisdiction Enforcement Act has overruled traditional concepts of comity, and it does not have a high threshold for enforcing those foreign judgments.